Good evening. It is Wednesday, April 11th, 2018. It is the monthly meeting of the Urbana Human Relations Commission. Could we please have a roll call?
Frances Rigberg Baker.
Here.
Carol Bradford. Here. Lisa Mosley. Daniel Larson.
Here.
Catalina Thomas. Peter Resnick.
Here.
Stacy Burnett.
Here.
Lolita Dumas.
Here.
Samuel Bindum. Brianna Donald.
Thank you. Looking over tonight's agenda, are there any additions, edits, or corrections? If not, is there a motion to approve?
I move we approve the agenda.
Second.
All those in favor, please say aye.
Aye.
Opposed, the same. Looking over the minutes from our March 14th meeting, are there any additions, edits, corrections that need to be made? If not, is there a motion to approve?
Motion to approve.
Second.
All those in favor, please say aye.
Aye.
Opposed, the same. Thank you. Next item is public participation. Seeing none, hearing none. And having no old business, we can jump right to new business. Cecilia.
Thank you. Well, I sent all of you copies and an explanation about this agenda item, the revision to the city vehicle ordinance. And so I was hoping to get feedback and perhaps a recommendation of approval for the request. Basically, the city is revising their vehicle for hire ordinance. And they would, in the city of Champaign and the city of Urbana works jointly together on this particular ordinance. And one of the things that we thought would be helpful if we added language that would allow someone who had gotten denied for this particular section that I indicated, and I'll just read it into the record. Who has been convicted, these people would be disqualified if they've been convicted within the past 4 years of driving under the influence of drugs or alcohol, fraud, sexual offenses, use of a motor vehicle to commit a felony, a crime involving property damage or theft, acts of violence, or acts of terror. These are the convictions that would be eligible for appeal within that 4-year time period.
Pardon me, Peter.
So the only thing that struck me about this, by the way, the recommendation that we get involved in it, I think is great, and I think that'd work out fine. The only thing that struck me about this, it construes it as you're disqualified and then you appeal it. Right. And I guess just the formulation of you are disqualified for having the conviction, and then you come back and appeal to, in order to get the license, seems sort of the opposite way that the human rights ordinance goes, where you could just simply say, if you've got one of these convictions, then you have an additional step in order to get the license, which is to go through this appeals process or whatever it is. And it's just the construction of it, but it struck me a little funny given the way we say, unless there's some reason to believe that the job requirement somehow is incompatible with this, then you are assumed to be discriminated against. Whereas this seems to reverse the assumption.
I don't think so.
Okay.
Because it is not, you said in there, unless there's some reason. Well, these convictions are considered, in this context, to be reasons. And that's all I would say.
So think of the way we describe now the employment policy.
Yes, but it's not just a conviction.
Well, so
It's
one of the ones on
particular conviction.
one of the ones on the list is fraud. So let's start with that one.
Okay.
Okay. So just having committed a fraud does not necessarily disqualify you from being a taxi cab driver.
Right, I think that the list requires some examination, but I don't think the general shape of it requires.
So the fact that you are convicted of some drug or alcohol offense does not in and of itself disqualify you. It's a
That's right.
particular kind of drug or alcohol offense that we would be concerned about. We would
Right.
ask the person, let's talk about this because we want to find out, are you an alcoholic? Are you able to, drive and not be impaired? All those things would,
Right.
on appeal, be asked. It's not the conviction itself that's disqualifying, it's the type of conviction.
Right, and maybe this list needs to be firmed up in those respects, and in fact, I think it does, but some of the things on there, as far as I'm concerned, should function this way. Sexual assault, for example.
Sexual assault is not on the list. It says sexual offenses. This is my concern.
Oh,
Is
yeah.
if we want, and what we don't want to do, I think, is go through an enumeration of every possible one of the offenses under this category because they will change over time. I think we do want the person to come forward. If they have a sexual offense, we're going to want to say, okay, you're going to have to explain that. If you have a drug offense or an alcohol offense, we want to say, in order to get the license, you have to explain what that offense was. But we don't want to enumerate every crime because that will be untenable. Laws will change.
I'm very sympathetic to your point of not putting the burden of proof in the wrong place. However, I think in the interest of public safety, which I feel equally passionate about, in respect to these situations when you're in an enclosed space with one other person and have no defenses, basically, that certain kinds of crimes should disqualify you. I don't have a problem with them disqualifying you. And then you can appeal, and if somehow it's not quite as it seemed, maybe you should be granted the license. I don't think we should be so quick to not see this as a serious problem.
And I will point out, I absolutely understand and absolutely agree that it is quite serious that, for instance, someone who has committed sexual assault, for whom there is not an exceedingly long explanation of why things have changed, and it would have to be impressive, I think, for any of us to conclude that this person is justified having such a license. I absolutely agree that we want to disqualify those folks, but disqualify those folks after having found out that something is different. And it's just the presumption, right? There's, okay, you can get the license, even if you have one of these convictions, if you come and explain how that conviction does not apply to this particular case.
Well, for one thing, you're asking people who've been convicted of heinous crimes to talk themselves out of it? I mean, people can be quite convincing sometimes, and what we want to do here is, I think, is to say that certain crimes are so prima facie public danger, potentially public danger, that you can do anything you want, but we don't want you driving taxis. Like, we don't want you to be alone in a vehicle with an unsuspecting citizen, a child, an old woman, or whatever. Or we don't want you to do that at least until a certain amount of time has passed or something like that. I don't think that's necessarily a good idea.
Vasilia.
Okay, I think I need to explain what I'm asking of you. Number one, these convictions, after 4 years, will not preclude you from getting a taxi cab license.
That's right.
Therefore, the goal is to take a look at anyone who has been denied within that 4-year period. Just give them the opportunity, if they so choose, to come before the hearing body and explain how they've been rehabilitated and have not necessarily, they're not a risk from a public safety standpoint. That's the goal of a hearing. They can bring witnesses, they can have letters of reference, they can answer any questions themselves that you may have. But that's the goal of the hearing. It's not to debate whether the heinousness of the crime that they've committed or anything like that. Because after 4 years, these particular crimes in Section 4 does not preclude you from getting a license. Does that help? Yes. Okay.
I just wanted to add, I had to do something like this similar when I worked in child welfare. If we hired individuals who, once a background check came back and showed something in their record that would give pause for whatever reasons, because you're working with abused and neglected children, we had to present information and evidence to the department as to what has happened since this conviction, that this person could show that they, you know, should be able to still have this job. And I'm glad that we had that, because not every conviction, you have a conviction, but they're not all heinous. It may fall under that category, but it gets touchy because it could be everything from touch to all-out sexual assault. So I think having the opportunity to come forward, share information about the conviction beyond what we see on paper, and talk about what they've done, whether it's counseling, community, whatever they've done to show that they are regretful and that they have made strides to change their life so that they can move forward with their life, because everybody makes mistakes, and we want to make sure, and it sounds like what this does is, after 4 years, this won't even be held against you. But if you can show us right now some things that will help us to determine, maybe we can wait, I don't know if it's, I'm going to use the right terms, but waive or overlook that, we'll give you that opportunity. So I like that, because I work with so many folks who are not able to get jobs because of things they did in their past. And so I like the idea of people being able to come forward if they want to say, hey, here's what I've done, that type of thing.
Because the ultimate determination that the hearing body would be making is this person too much of a risk from a public safety standpoint? And that's after hearing all the evidence and their statements and answering questions from the hearing body. That's what you would be deliberating, whether or not this person has convinced you with their documentation and their testimony that they would not be a risk from a public safety standpoint. And the model and the idea came as a result of what the University of Illinois also does, which I think is a wonderful program and idea, where people who otherwise would be eliminated or disqualified for a position because of a criminal background situation, they are given the opportunity to come before a hearing body and explain and present, letters of reference and things like that. So that's where the idea came from.
And but that's different from what Pete is saying. No? I thought you wanted to say that basically there shouldn't be the 4-year
No.
thing.
Oh,
Okay.
well,
I
so
misunderstood you.
Let me go through the two things. First of all, to address one of the issues before, you'll also note that one of the items in the list of disqualifications right now is on the National Sex Offenders Registry, and that can't be appealed. So if a person is convicted of a crime that ends up on the National Sex Offenders Registry, they're done. They don't have a path of appeal. I personally find the 4-year thing a little odd personally, because if you've been convicted of a violent murder and you're out for 4 years and now you can just get a taxi cab license, that's interesting. But from a discrimination point of view, I say, okay, if this person has gained parole or has gotten out for whatever reason and now is considered to be back in society, we should check, ask the questions, but it's perfectly, having that exception to say after 4 years, okay, that's
That's
fair enough.
saying, like, we're making a generous assumption that that means 4 years of good behavior, and
Absolutely.
we assume you're going to
The
be okay.
only thing that I was pointing out was right now, those convictions within 4 years appear in the list of disqualifications, and then there's this new bit that's added that says,
You can-
for those things, for only the convictions within 4 years, you can appeal. And I was only suggesting that the other way to construct this is to pull that section out and say, this is an additional qualification, that if you have one of these convictions within 4 years, then you have an additional step to take, which other people don't, which is this appeal. Right? To basically reverse it. And it
You may
makes
not
it.
change what actually happened.
Not change what
Oh,
actually happens,
okay.
just simply reverse the sense of it, because that goes better with our human rights ordinance that says we are presuming you to be, okay for the job unless there is evidence otherwise. And it just sort of, if we take section 4, move it and say, here's an additional qualification, you must go through an appeals process if you have one of these within 4-year convictions.
Oh,
That's all I was saying.
okay. I'll calm down now.
I love violent agreement when we finally get there.
Okay. I will definitely talk to the staff person here about that idea, and keeping in mind that we're also working with the city of Champaign. on this.
Absolutely. And I think, this is an important point that Fran obviously identified, is to point out the procedure should be exactly identical. This is simply a question of the language of the ordinance to make it
Flow.
And if there's a real objection and they want to leave it in this direction, I don't think we have a heart attack or anything about it, but I think just presentation form, it would go better that way.
Okay. Well, one of the things is that you guys should know is that Urbana handles this part of the ordinance. So it wouldn't be Champaign and Urbana. It would just simply, because this is our responsibility and our agreement,
So we'll be the only appeals body, not the Champaign side.
correct,
Interesting.
correct.
I have a question about the so-called ride-sharing companies like Uber and Lyft. They're not covered by this in our city, but it is possible that we could make it so, yes? In the city? Okay, I'm just curious because, in my opinion, they should be. And I know that some cities do, and in U.S. and Europe, require that. Okay.
So the question is, number one, is the commission interested and generally agree to the notion of being the appeals body? Okay, I think we need a motion.
Can I ask a question before we motion?
Yeah.
Because I wasn't sure on how much of this are we doing within this? Like, are there additional meetings? Or I know there was some language about making yourself available for different
Well,
things, so.
based on past history,
Mhm.
the staff, Urbana staff person indicated that there may be one, no more than 2 hearings, periodic hearings a year.
Okay.
And what is the time frame of the hearing? Is it like an hour-long thing generally? Is it 10 minutes? Is it?
We have not gotten to writing the rules and the procedures first I wanted to make sure that you guys would be comfortable being the hearing body. But as we move forward, we plan to write the hearing rules like our commission, like the hearing rules for our commission, and be very clear on response times and those kinds of things.
I think, especially if it's one or two a year, fitting them in like on a monthly meeting night and saying we'll have an hour additional or beforehand to
Yeah.
do the hearing, that at least doesn't cut into, make a big additional burden.
Yes.
So,
So
you
we
need
need a
a,
motion.
okay. I'll make a motion to communicate to appropriate city staff that the Human Relations Commission is willing to take on the task of being the appeals body for the, what is the name of it?
Vehicle for hire.
Vehicle for hire ordinance.
Okay.
Is there a second?
I second it.
Any last comments or questions? Okay, all those in favor, please say aye.
Aye.
Opposed, the same?
Okay, one other thing I just want to be clear. The entire commission, not a subcommittee of that commission, correct? Okay, thank you.
We can stay with you because it's staff report time, I think. Where would you like to go?
I'm sorry. Let's go with the EEO.
All righty, looks like we got 2 new applications and 1 renewal. We've got Sublon Construction, we have a staff recommendation for 2 years. We have Upcycle Products, Inc., staff recommendation for 2 years. They're very small companies. And then a renewal of Western Construction Group for 2 years, staff recommendation.
Omnibus move to approve with staff recommendations.
Is there a second?
I'll second.
Discussion, questions, comments?
I had one quick sort of general question, and I'll just use this time to ask it. I heard there was some movement in the federal EEO guidelines about being able to sue smaller than 15-person companies under those. I'm wondering if you have heard anything about it. It was a little news article, but I'm wondering if you'd heard anything about it, and if not, whether you could figure out whether we need to make adjustments to our rules about small companies.
I have not heard anything about it, but I will definitely research it and find out.
Excellent.
Thank
Thanks.
you.
Any other comments or questions regarding the motion on the floor? All righty, all those in favor of the staff recommendations, please say aye.
Aye.
Opposed, the same? Excellent, thank you. We go into the activity report contact log? Or,
Yes.
Excuse, oh,
Basically, there were 2 additional contacts since we last met, and one will probably, the second one on the sheet will probably result in a formal complaint being taken, but it has, I'm just in the early stages of it.
Okay.
Okay. And the other thing, do all of you have a copy of this?
we do?
The City of Champagne's Human Rights Commission also wrote a press release in reference to what was it the bus company?
No.
Huh? I'm sorry, Peter.
No, I didn't.
Uh-huh. And they included Urbana. And so what you have in front of you is their press release, and I just wanted to kind of FYI, so if you happen to see it out there, you guys will know.
All right, thank you. Is there anything else?
No, that's it.
All righty, does anyone have any announcements? Gesundheit. No announcements, we will wish everybody a happy month, and we'll, oh,
No budget?
No budget.
no budget.
No budget, okay. Okay.
All right, everybody, have a good night, have a good April, we'll see you in May. This meeting's adjourned.
Thank you.